All right. Hello, everyone, and welcome to the Law 2025 online residential property shape the debate. I'm joined by our expert speakers, David Keithley and Richard Snape. This session is due to last about 1 hour and is going to cover the latest developments in residential property, which are featured in our Law 2025 online course, as well as your pre-submitted questions. If you didn't get a chance to submit a question ahead of the session, make sure you don't forget to sign up for the solicitors group emails, and that will mean that you get alerted on upcoming residential property shape debate sessions, as well as free, relevant, professionally curated updates to support you in practice. Now, this session is sponsored by Watchman Insurance, and if you didn't know already, Watchman is a specialist insurance policy available only to solicitors. It provides insurance for unoccupied properties and has been revolutionary in changing the way probate solicitors protect their clients' estates by reducing initial pressure on your funds while you're still trying to access the estate and sell property. Watchman achieves this as solicitors don't have to pay a full upfront premium. Cover is secured just by paying a small deposit, excuse me, and then continues throughout the year with a daily premium charge that is deferred until the property is sold or transferred up to a year with no finance agreements or cancellation charges necessary. It's also available to homes where clients are in care or have reduced legal capacity. Getting started is easy. If you would like to learn more about Watchman, you can contact our helpful team on 01935 389 812 or via email at inquiries@watchmanservices.co.uk. And if you haven't already, you can still purchase the full law online today, which will give you full access to the sessions and topics that are going to be discussed today. So just quick instructions, not that they need them. David was admitted as a solicitor in 1982. Until his retirement from full-time practice, he was partner in and head of residential property at a legal 500 firm. Now, David uses his extensive experience and understanding of practical conveyancing to cut through the academic niceties and make things relevant for the busy practitioner, and is a contributing editor to the Law Society Conveyancing Handbook. As part of Law 2025 Online, David's sessions include acting for the elderly and vulnerable clients, and restrictive covenants and rights of way. And secondly, Richard, who has been the head of professional support at David Jones Bold since 2002, speaks at various courses for law societies all over the country, public courses, in-house seminars within solicitors' firms, and has also talked extensively to local authorities and central government bodies. His specialism areas include both commercial and residential property, in particular in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. And as part of Law 2025 Online, Richard's sessions include new build conveyancing, tips and traps, and conveyancing and the family home. So I will shut up now and I'll let the speakers get on with their questions, starting with the first delegate question.
Thank you, Adam. The first delegate question we've received is, thank you for covering the issue of where a property is being sold by an attorney and the need to appoint a second trustee. Would you please explain what should happen and if another trustee needs to be appointed in the following situation? A and B are attorneys for C. C has lost capacity and has not appointed any other attorneys. A, B and C jointly own the property together. So as A and B are both legal owners and co-owners and attorneys, does another trustee need to be appointed to overreach C's beneficial interest in the property? Well, there's two aspects to this. There's probably the strict legal position, but there may be a more practical issue in respect of the land registry. Now, obviously, Richard will chip in, I suspect, as well. But basically, my immediate reaction is that from a legal perspective, if A and B, in their appointment of attorney to C, if the appointment of A and B as attorney for C allows A and B to act jointly and severally, then strictly at law, I suspect they probably don't need to appoint a third trustee because they can act jointly and severally, so one of them can sign independently of the other. If, however, the power of attorney does not allow them to act jointly and severally, then from a strict legal perspective, I think a third trustee, sorry, would need to be appointed by A and B using their powers under the Trustee Act to appoint a third trustee to act on behalf of C. Now, that's a strict legal position. I think from a practical position, you've got to factor in what would the land registry make of this. Now, I'm sure I'm not alone in saying that what the land registry do and what the law says are not always the same thing. There's a whole raft of people now at the land registry who may not be as experienced as they could be, because there's been a whole raft of new people appointed. And there are some rather strange requisitions or strange comments sometimes coming out of the land registry. So from a practical perspective, I think to avoid any issues with the land registry, I probably would appoint a third trustee, even though in law it may not be strictly necessary. Really, just try and avoid the issue becoming a problem. But it's quite straightforward for A and B to appoint a trustee. Can be appointed within the body of the transfer. It doesn't have to be any big deal. It's just purely appointed for the purposes of receiving the monies arising on the sale. Richard, have you got any?
Yeah, I agree with you, but I personally, it is so easy to get a third trustee appointed by the existing trustees that I think I would just get a third trustee appointed anyway. What have you lost, basically?
Yeah, yeah, I think that's the point I was making. It's yeah, probably the practical position is just do it. It's not going to you're not going to be penalised for doing it, and it's to avoid any issues with the land registry at a later date. So hopefully that's answered your question. The delegate didn't leave their name, so I don't know who it was, but thank you very much for that particular question. So very useful. So moving on then to other questions which have been submitted for me and for Richard. I'll take them in an alternate forms. Starting off with a question for me. If I'm acting for a buyer and the seller is acting via a court of protection deputy, how can I be sure that the deputy is allowed to sell the property? Well, the first point here is that you'd need to obviously see the order of the court appointing the deputy, and you'd need to look carefully at the wording of the order. The magic words you'll be looking for is that the deputy is appointed to deal with all property and affairs. If that wording is used, then that would extend to the power to act to sell property, land and property. If it doesn't contain those words, or if it's limited in some other way, then it's possible that the deputy does not have power. Now, the other issue to consider is to check that the deputy order is actually still valid, and that can be done by a search of the court records just to make sure that the order that you're being presented with hasn't been superseded or suspended by a subsequent order. So yeah, there's various issues to consider there. But yeah, frankly, the magic word you're looking for are all property and affairs. That would be the default position. But say sometimes the court do place limits on the powers of deputies if there's some surrounding circumstances. So yeah, it's a question of looking carefully at the order, looking at the wording of the order, and making sure that the order is actually still valid and hasn't been suspended or overtaken by a subsequent order. So, Richard, you want to add anything to that?
Not really, tell you the truth, David. I think you've summarised it perfectly.
Okay, good to know. Thank you very much. Okay, so moving on to a question then for Richard. Do we know when the changes to new build guarantees are coming into force?
Yeah, this is the dreaded Building Safety Act. I mentioned this in the context of new builds, but I feel obliged to mention the Building Safety Act at any time during any course, regardless. I haven't seen a date for it. I don't know if you have. I have looked. It's what it is. It's section 144, 145 of the Building Safety Act. which for quite logical reasons in terms of limitation periods, basically say that new build homes warranties are going to have to be introduced for any new build dwelling and it's sold freehold or a long lease, more than 21-year lease. And if it's a block of flats, you'll need a new build home guarantee as well for the common parts. And it will have to last for 15 years. The 15 years is, I'm not sure I mentioned this in my course, but the 15 years is because that's the limitation period nowadays for Defective Premises Act claims in relation to new build dwellings and conversions and also refurbishments. It used to be 6 years. And obviously standard new build guarantees at the moment will not cover the potential liability for that time period. They did actually introduce regulations it was as long ago as April of 2023, but all the regulations basically do is allow the Parliament to pass, or government to introduce further regulations. It was definitely meant to come into force in 2024. And if you look at sort of on the internet and the likes, says, oh, this is coming into force this year, this is coming into force this year. It didn't. And I still haven't seen the date. They've got to pass various regulations in relation to it, primarily dealing with the contents, who can give you the new build guarantee and what the insurance policies are going to be, and making sure that the insurers don't become insolvent and the likes. If you remember what happened to Alpha back in 2018, those Danish insurers and underwriters who went bust and left 21,000 people on new builds without any guarantees. I can understand why they want to do that and the likes. I should also stress it's all new build dwellings, and the actual 15 years runs from not the date of completion of the building, but the completion of the sale of the property, either freehold or a long lease. But I haven't seen anything specific lately.
No, I haven't either. I mean, it just also rather begs the question of what's the position going to be when you've got a building that's built under the supervision of a professional consultant certificate rather than
well, that's it, isn't it?
warranty. Yeah. So
I mean, if professional consultant certificates and architect certificates go as a consequence of this, it's no bad thing.
Yeah.
Because most of them are not worth the paper they're written on anyway.
Yeah.
And do you remember that Hunt and Optima case from a few years back, from 10 years ago now?
Yeah.
Where people didn't pick up on it, where they basically said you're suing the architects under in tort and not in contract. You don't have a direct contract with the architects, and you can only sue in tort. It was reasonable for you to rely on the architect certificate, and as they'd exchanged contracts before it was in place, they couldn't sue anyway.
Yeah.
I was talking to somebody about the actual defects in that particular case, and it's who was involved in the case, and it was primarily sewage build-up in the basement.
Right.
They hadn't actually attached the pipe, the sewage pipes to anything. They were just kind of pumping all the sewage into the basement.
Yeah.
And also they'd attached all the electricity meters for the wrong flats. Who were paying the wrong person's electricity. But if they go as a consequence, which seems to be the case, then no bad thing. I presume it's just getting delayed and delayed and delayed. The change of government hasn't helped, obviously, but it's getting delayed because they're still trying to get who provides the policies sorted out and the likes before they can introduce the regulations. But no, I can't tell you a definite date.
There's various consultations going on, isn't there, with the government saying they're going to launch consultations for this, that, and the other, and they obviously launched the common hold white paper and say they're going to consult on changes to the freehold and leasehold reform act. So there's a lot going on. I suspect things like that are being pushed into the long grass.
I mean, they've got judicial review against them in the summer in July. They're going to hear the case on getting rid of marriage value and the likes, and that was absolutely inevitable.
Yeah,
that's not going to come in its current
form. It's not even coming to force yet. So yeah, like you okay, right. So we'll crack on. Another one for me, which is if I have concerns about my client's mental capacity, what sort of questions should I be asking? Well, that's an interesting point. We might question the mental capacity of anybody dealing with conveyancing at the moment, to be brutally honest. But essentially,
I was going to say that if your client has concerns about their solicitor's mental capacity. But
The other way around, what sort of questions should the client be asking the solicitor about his mental capacity? Essentially, mental capacity assessment is not something, as I did say, I think in the session, it's not something that we are actually trained or qualified to advise on, but we do need to at least be aware of the warning signs. The critical point really a critical point really bear in mind is that capacity assessment is both matter and time specific. And so the nature of the capacity that your client will need will be dependent upon the nature of the decision that they're trying to make and the time at which it's being made or required to be made. Well, it's a simple question of, do I want tea or coffee? Then obviously it's clearly a much lower level of mental capacity is required to answer that question than do I want to enter into this land transaction and give all the proceeds to the Battersea Cats and Dogs home? And there's different issues to be considered there. So I think generally, if we're taking the fact that if you're concerned about your client's capacity in the context of a complex residential or other transaction, then it's really a question of touch and feel and experience, and just going with your gut to some extent. I'll obviously take medical advice if needed, but as a starting point, I think the thing to do if you've got concerns is make sure you meet the client face to face, and please make sure that they're alone and you haven't got somebody in the room who might be prompting them for answers. But don't just sort of leap straight into asking detailed questions about the transaction and the legal issues involved. But start off with just a general conversation. It may be perhaps if to put them at ease, don't actually do this in your office. Maybe go and see them at home or whatever in a situation where they're perhaps more comfortable and familiar. And maybe perhaps ask them a few questions about their family and career. Obviously, you'd need to have obtained information from the family unless you know the background yourself, and perhaps ask questions about current affairs and past events. I mean, the classic one. My late wife used to do all this a lot. She dealt with the elderly and vulnerable quite a lot, and she would start off with asking basic questions about who's the Prime Minister, and what do you think about the Prime Minister, and who's the monarch, and stuff like that. But fairly basic questions. I wouldn't suggest that you perhaps ask somebody if they could name the name of the Shadow Secretary of State for some obscure portfolio, because politics geeks may know that, but most people wouldn't necessarily be fully up to speed with it. But it's not unreasonable to expect that somebody, even with a passing interest in, not even a passing interest in politics, would at least know the name, potentially know the name of the Prime Minister. But it's also worth asking the question several times in different contexts, and check the consistency of the answers. And again, it's a sort of a gut feel. And if you've got concerns about it, then seek medical advice. We are not medically trained. We would need to refer it out to a medical practitioner for advice. You would need to explain to your client that you are doing that and the reason why you're doing that, and you'd have to explain to them the consequences of them being found not to have mental capacity. And you'd need to make sure also that the medical practitioner is fully aware of the basis on which the context in which the capacity issue is arising. So there isn't a sort of a nice little checklist of questions that could be asked. It's sort of use your gut and feel. So, Richard, have you got anything to add to that?
Yeah, I've seen enough examples where the medical practitioners will not basically look into it. I think they probably don't want to get sued themselves, basically. But I mean, you should certainly be suggesting and urging medical advice. It's not a lawyer's job. And there are cases that are going back for over the years, which basically said that you don't have to make assumptions that somebody might be mentally incapacitated just because they're elderly, for instance, and the likes. There has to be some other pointer towards that. and it's not really a lawyer's job outside what you say to actually decide on people's capacity.
Yeah, I mean, the test really is, does the client understand what they're doing? Not they're perfectly entitled to make a stupid decision. The law will protect somebody from who wants to make a stupid decision as long as they've got the capacity to make that decision. The fact that you don't agree with what they're doing
Mm-hmm.
isn't a pointer for incapacity, and neither, as Richard said, is the mere fact that you're elderly would mean that you're
There
mentally.
is that within the Mental Capacity Act that you can lack capacity one day and have capacity the next as well.
Exactly. Yeah, which is why I say it's matter and time specific.
Mm.
It is very yeah. It basically, the Mental Capacity Act does say that the starting point is you are assumed to have capacity,
Capacity, yeah.
and unless it's been proved otherwise.
I have come across a couple. I mean, they were old, a long time ago, pre the Mental Capacity Act, which might change things, where people, solicitors were successfully sued for not spotting the client's mental incapacity. Not in reported cases, but to the extent the insurers paid out the claim, and they were both equity release. And it wasn't the elderly person or whatever, the person in a lucid moment who wanted to get out of the equity release. It was the kids who considered themselves to be disinherited. So I think you need to worry a bit about that as well.
Yeah, a good point. Also, the family members need to look at duress and undue influence, and that's a
Yeah,
separate issue, admittedly, but yeah, it is a bit of a minefield. I mean, the question, the phone call which always used to make my heart sink is that Mum wants me to act for her on selling the house, and she wants to give me all the proceeds. That sort of immediately set so many red flags and alarm bells ringing.
it's also deliberate deprivation of assets problem,
Absolutely, yeah. I'm doing
which
it so
doesn't
I
work
don't
if
pay
you're dealing with.
maintenance fee. Yeah,
These people, I mean, they read the papers, and every now and then there'll be something about how you can avoid care charges if you have to go into care. And the way you avoid them is don't get found out. If it's a deliberate deprivation of assets, and it is the local authority's job to find that out, to prove that,
yeah.
and it's not going to work,
Yeah.
basically.
Okay, so let's move on then. One for Richard. Would you suggest separate representation when acting for co-owners?
I'd certainly suggest it. Yeah. It becomes more of a problem when you're not married or civil partners, because if you're married or civil partners, the divorce courts or the family courts will get involved if the relationship breaks down, and you'll discuss declarations of trust. But outside things like tax and having kids of a previous relationship, the declaration of trust and the beneficial interest don't matter too much if you're cohabiting, or if you do two friends who can't afford to get on the property line unless you buy jointly. Or your examples, I think one of the more dangerous is the elderly parent buying with their adult child. There's potential for undue influence, especially, I mean, they're pointed towards undue influence, supposed to be a manifest disadvantage. You stand to lose, a lot more than you stand to gain. Doesn't mean to say it is undue influence, but that's when the lawyers need to be on their guard. And a nice, easy example within the family home would be two people, cohabiting couple, first-time buyers. Let's say one party buys in 9/10 of the purchase price, and another tenth, the other person in 10th, and they decide to be beneficial joint tenants. And if that relationship breaks down, then all other things being equal, unless you've got an elaborate declaration of trust, you get 50-50 of the proceeds. And that's the manifest disadvantage. It might be because they're in love and they think it's going to last forever. It might just be because one side listens to the other. And I'd certainly tell them to be independently advised every last time. Whether I insist on it is another matter, because you can't insist on it every last time. But if I was suspicious as to background circumstances, I'd even insist on it once or twice in your career, perhaps.
Yeah, and I think that's probably a fair comment that if it's fairly clear that the money is being provided in unequal shares, then you've got a duty to warn and a duty to say this is what we think you should be doing. It's not an easy subject to broach. I mean, people will always say, "Well, of course, we're not going to fall out, or it's not going to be a problem." But it's life.
You don't go and tell them. Of course, you realise it's not going to last.
Yeah, it's broach it gently. So.
I did come across one. It was again not a reported case, and it was quite a few years ago. I think I might have mentioned it even in the webinar, that it was a a woman who'd recently gone through a very messy divorce, and the same firm had handled the divorce, different solicitor, and she soon afterwards, she was with the new man in her life, wanted to transfer the house into joint names, her solely owned house. And the man was there, sort of supporting her in the likes, what shall we be? And the solicitor basically said, I'm going to have to discuss this minus your partner, and she wouldn't let him, so he didn't. It's a rarity, It's not the kind of thing that happens every day or year, but it might just happen in your career. You might have to say, you need to be separately advised.
Yeah, that's right. Again, it's the experience is there's something that's watching out for them. I mean, people just be alive to these situations. It's coaching is another thing to watch out for as well. I mean, this is again where it's just again I had a situation in my own practical experience is that I was alerted to by the receptionist that while the clients were waiting to see me, one of them was clearly schooling the other in the answers that she was supposed to give to the questions which they thought I was going to ask. And it was fairly clear that that the lady was being coerced into what was going on. And I was alerted to it by an alert lady on reception who had a quick word with me before showing them into my office. So it was sometimes it's surrounding circumstances, and I wouldn't.
Yeah, I remember one where it was going to be it was elderly mother and two adult children, an adult child and their partner, and they're both selling their existing houses. The mother's house is worth a lot more money than the child and partner's house, and the solicitor, well, the child and partner turns up without mother. Mother wants to be a joint tenant, and here's what she says about it. And we've left mother in the car because she can't get up the stairs, basically. In the boot. I don't know if she was in the boot or not, but she was in the car. And the solicitor, well, I can come down and talk to the mother in the car, and they just wouldn't let her. And again, thankfully, they're rarities. And it's not whether you're doing the undue influencing, it's whether you suspect or should suspect the other party is doing the undue influencing.
It's a sad fact that you can't always assume that family members are acting in the best interest of other family members.
Yeah, and it isn't just, it's really worth stressing, although I did mention it in the webinar, it's not just undue influence is not necessarily threats and coercion and physical violence and likes. It's just one party leaves business decisions to the other.
Yeah.
They are naive in the ways of business, and that's potential undue influence. And if there's a manifest disadvantage, you lose more than you stand to gain. You tell people to be independently advised. I mean, the other classic is what we talked about previously. If a parent wants to give their house, their only, the major asset, to somebody else whilst they're still alive, that's so much scope for them. But I can't think of a bigger manifest disadvantage than that.
Yeah, absolutely. Okay, all right. So move on. We've got lots of questions to go through. The Court of Protection seems to be quite popular. The next question is, can a Court of Protection deputy buy a house on behalf of someone who has lost capacity? Well, the starting point is probably not, unless the court order actually allows the acquisition of property. Now, it's not unusual for, the person who's lost capacity may well be in a house which is unsuitable for them, and their property may be sold to purchase another one which is more suitable for them. That may well have been envisaged at the time of the application, and so the order might actually authorise the sale of the existing property and the reinvestment of proceeds into an alternative property. But if it's something that it was just all property and affairs order, then the probability is that doesn't extend to actually purchasing a property on behalf of the vulnerable, the person who's lost capacity. So it's probably the safest way to proceed in that situation would be to ask the court whether the order that they've made in the court's view extends to allowing the purchase of property, and if not, you would need to seek an order authorising the deputy to do that. That's not going to be a quick process because the Office of Public Guardian is not the quickest in the world, of course, protection, not the quickest organisation in the world, but it's something which I'm afraid you may well have to encounter. So again, it's a question of looking closely at the order, and if there's any doubt, ask the court to clarify. Any thoughts, Richard?
Not really. I mean, that's basically what you should do. Basically, it's not always clear, but that's, I think, the starting point is now.
Yeah, okay, no problem. Question for Richard. Are estate charges and maintenance charges always estate rent charges?
Have you got 3 hours
Yeah.
on your hands? I wish to goodness they would tell us exactly what a rent charge is. Sometimes it's blindingly obvious it's a rent charge and it's called a rent charge and the like, so all these estate charges and management charges. They should have put something in. They had every opportunity of putting something in Leasehold and Freehold Reform Act to make it clear. My gut feeling is that they're not, because they're trying to enforce positive obligations. Basically, maintenance is a positive obligation in freehold land. Positive covenants don't bind third-party purchases, which is why you use the sort of concept of a rent charge as a way of enforcing via the rent charge, and also the Section 121 of the Law of Property Act and implying various rights and the likes. But if I was acting for a purchaser, until I've seen a case on it, and certainly never been a reported case on it, preferably an appeal case from the upper tribunal on it, if I was acting for a purchaser of not just a new bill, but a new bill from 10 years ago with estate charges on it, I would assume it was a rent charge. So my answer is, I don't think they are, but I would assume they were if I was the purchaser, and I'd want Section 121 of the Law of Property Act excluded if it was a new build in the transfer, which most builders are now doing. They weren't 4 or 5, 3 or 4 years ago, but most builders, vast majority, will now exclude Section 121. And if they say this isn't a rent charge, it's it's an estate charge, it's a maintenance charge, or whatever, I think my answer to that would be, well, what's the problem with excluding Section 121 just in case? And most developers accept that now.
Yeah, that's a good point. I mean, I agree. I think the basic reaction is that no, they're not. The rent charge makes it quite clear that a rent charge has to be secured on land effectively, and a positive covenant is a payment under a positive covenant is a personal obligation. It's not secured or charged on land, and therefore it can't meet the very definition of a rent charge. I think taking the counter argument from Richard there, if I was acting for the seller in that situation, I would probably kick back and say, well, it's obvious that it's not a rent charge because it is not secured on land. But again, that's a matter of negotiation between the parties. I'm paying.
But again, I mean, just if you say it's not a rent charge, what's the problem with excluding Section 121 just in case?
Apart from the cost.
Well,
that's another.
And again, most developers will do that nowadays. I remember a few years back, I remember hearing several stories like this of people on a new build receiving the draft transfer and Section 121, the provision that says if you don't pay the rent charge within 40 days, the rent owner can create a lease over the property or enter the premises, whether demanded or not. I remember several occasions people telling me that they got the draft transfer, Section 121 wasn't excluded. They contacted the developers, solicitors, we want Section 121 excluded. And they got by return a new version with Section 121 excluded. So they contacted the developers, what's all this about? To be told we've got 2 different versions of the transfer, one for people who ask for Section 121 to be excluded, one for people who don't. And they just immediately accept the argument if you put it, well, they'd let you fall into the trap otherwise. The bigger problem, I don't think, is new builds anymore, although there's some developers holding out. The bigger problem is all those, well, no one's quite sure because of the definition of a rent charge, but all those people who bought before we ever heard there was a problem. Bristol case, Robertson Lawton from the summer of 2016.
Still rumbling on, isn't it? But why on earth Section 121 wasn't removed from estate rent charges at the same time as they were for regulated rent charges in the
Fixed sum rent charge.
beyond it.
It's beyond me. There is another. It's nothing to do with new builds, but there's another problem with that. I don't know if you've come across surfacing, because a lot of the Bristol and Manchester rent charge. I used to live in Bristol and had a property with a rent charge on it, fixed sum historic rent charge, 2 guineas a year, and they Section 121 no longer applies to the historic rent charges, like you say it does to estate rent charges. A lot of the historic rent charges, the fixed sum rent charges, had an express right of entry in the large majority. So the Section 121 doesn't imply the right of entry, but it's still express.
Yeah, again, I suppose the people who own those things will do whatever they can to try and hold on to whatever they've got.
I think they've made a huge mistake in the legislation, but that's for another day.
Yeah, you wonder what. Yeah, I know. I did read the parliamentary debate about it, because it's not the most scintillating thing, but it was made fairly clear in the debate that it was a deliberate decision to exclude estate rent charges.
I can actually understand why estate rent charges still, Section 121 still applies, because the threat of creating a 99-year lease over your house if you don't pay for maintenance of the roads and the open space and the likes is a good threat, a good sanction to make you pay for the maintenance of the roads. The problem is, because in that Robertson Lawton case, when you've actually paid for the maintenance, if you don't pay for the maintenance, they create the lease over your property, and when you have paid, that the 99-year lease stays.
Yeah, indeed. Yeah,
that's the real issue.
The lease has to be surrendered. Has to actually be, so it doesn't go away simply by virtue of paying the arrears.
They should have. If they wanted to introduce anything, it should have been once you've paid off the arrears, the lease disappears.
Yeah. I did see a transfer only in the last 6 months on a new build estate, which varied Section 121, but varied it to make it worse, and said that the time period was 7 days, not 40. And so, that was never going to.
Again, it'd be interesting to see if there's an express right of entry, because they are so common in Bristol and Greater Manchester. If there's an express right of entry, is the problem still there?
Oh, well, keeps us in.
I'm all for badly drafted legislation.
Yeah, absolutely. Yes, it's That's the Building Safety Act's the gift that never stops giving, isn't it? But there we go.
Wait until the renters' rights bill comes in.
Right, so let's move on. If a right of way has not been used for 20 years, is it still capable of being used? I think the honest answer to that is yes. The case law seems to suggest that if something isn't used, it doesn't disappear. It might possibly be in abeyance, but it doesn't mean that the right of way has been extinguished. And I did actually talk in the seminar in the webinar about a decision where a right of way was existing over a private lane for one house, and rather that house sold a piece of its garden to the neighbour, and in the transfer, the neighbour covenanted that they would fence off the piece of land they bought so as not to be able to access the right of way. And it was argued that the restrictive covenant was incompatible with the easement continuing. But the court said even in that situation, that wasn't the case. The restrictive covenant basically put it into abeyance, but it didn't operate as a surrender or an extinguishment of the right of way. So I think probably the safest way to proceed is that if something is there and hasn't been used, then assume it's capable of being used. And if you've got concerns about it, then get it surrendered, get it extinguished. Because you can't. The fact that somebody's not using it doesn't mean it goes away. Is that with you?
Yeah, I mean, it's this. People have this quaint notion. It's the same with public rights, public footpaths, and like people think that 20 years use gives you the right, therefore 20 years non-use takes it away, and it's just not true. I mean, the land registry, unless an express deed of surrender, wouldn't accept that the easement's not there. Did you mention that? You remember that Ben and Harding case, 1990?
No.
It's a it was agricultural land, and it was a right of way that had been created via an enclosure award in the 18th century when the land was enclosed, and it hadn't been used for 175 years. That's a heck of a stat deck to swear, but it hadn't been used for 175 years, but they still resurrected use after 175 years. And if that's not been abandoned, then what has,
Yeah.
basically?
And I think it's probably safer to assume that, a right of way will continue to exist, or any easement will continue to exist unless and until it's absolutely extinguished or
Express surrender.
expressly surrendered. Yeah. Yeah. Okay.
And if not, I mean, you can think about a policy as an alternative, I suppose.
Yeah, you could do. It's the policies are all over the place, aren't they? So
Well, the policies have got a lot of provisos to them.
yeah. Okay, so moving on. Oh, yeah, the BSA's popped its head up. Do you think the BSA will result in people not wishing to be directors of a right to manage company? That's for Richard.
Yeah, the Building Safety Act. I mentioned this and I didn't actually mention it. I mentioned higher risk buildings in the new builds course. Because if you've got a higher risk, this is England only, but if you've got a higher risk building, which is 18 meters or more in height or 7 or more stories with at least 2 residential units, so it includes mixed use. And there's a whole different ball game of things that have to happen. Like, you have to register the higher risk building. If it's a new build higher risk building, no one's allowed to residential occupation until it's been registered and you've got building regs completion for the property, for the whole building. And there's stringent criminal offences attached to it. The accountable person, the person in control or responsible for repair and maintenance of the common parts could be breaking the criminal law. And if the building safety regulator asks for a safety case report for the building and you don't provide it within 28 days, you're breaking the criminal law. You've probably got implications for your insurance policies as well. And it applies, unlike the leaseholder protections, where they don't, the service charge caps, which don't apply to residence management companies if they hold the freehold. Higher risk buildings does. The directors of a residence management company might just be opening themselves up to criminal offences, quite serious criminal offences, as might people in a right to manage company. Or if the government has their day when we all are conveying common holds in the not too distant future, the directors of the Common Hold Association, people queue up to be directors on new build developments of residence management companies because they think they can control the whole thing. I wouldn't dream of becoming a director on a higher risk building.
No, no, I agree. Certainly not a high risk building.
Yeah. I'd say it gives one of the things that gives the lie to this idea that we'll get rid of leaseholds and all have common holds in the future. The Common Hold Association will have to manage the property and they'll have to, in a higher risk building, deal with the incredibly complicated provisions.
I mean, they've said the white paper obviously is proposing to almost effectively do away with the existing notion of common hold and replace it with common hold version 2.
It's still, I mean, it's still you're still going to be, it's still a residence management company.
Absolutely, yeah. And so the issues are there. I mean, perhaps the starting point is that fundamentally, is there anything wrong with leasehold as a concept? Probably not. The problem with leasehold is the fact that it's been exploited in such a way by investors and others seeking to monetize it and to use it in a way that is not in the best interest of the individuals who have the leases. So, from a fundamental concept, it's probably not anything wrong with it, but the way in which it's been allowed to be monetized is
the reason you have leases in blocks of flats is because what we mentioned previously, if it's freehold, you can't enforce positive covenants against third parties, and it's absolutely essential when you've got common parts, and it's no more feudal than freehold is.
Yeah, again, this sort of talking about it being a feudal right, and this sort of whatever it's overstated. I mean, I can see that, clearly, leaseholders have got gripes, and you can understand that, but the issue probably is not the basic concept of leasehold, but just the way in which it's been
used. And I mean, it's bad enough if you got residence management company with 999-year leases and 3 or 4 flats in a townhouse conversion. If you've got a mixed-use development with 50 flats and 20 commercial units, then you're going to have somebody else managing it, and they're going to have to charge you.
Yeah. I did notice in the white paper there was reference to management charges being capped by managing agents and imposing time limits on fees for completing LPE ones or whatever. I think that's long overdue.
Long overdue, and they're not even consulting on it then at the moment.
Not yet.
Sales information requests and things.
I've seen, I mean, I'm sure we've all come across, there's a situation where one particular company, I can't remember who it was now, basically said that our standard fee is X. We'll provide you with an expedited service if you pay us a fee of 3 times X. But if at the time we receive your request, we're busy, we won't expedite it, but we won't refund your additional fee either. You know, it's abuses like that which, you know, are the problem.
Oh yeah, and the escalating ground rents in the past as well. But yeah.
Okay. All right. So moving on. Is it true that if a restrictive covenant has been breached for more than 20 years, it is no longer capable of being enforced? Oh, okay. Well, let's take this back to basics then. The UK Finance Handbook, of course, does say that if you're happy that it's been openly breached for 20 years and there's been no enforcement, then they won't insist on an indemnity policy, but that's just the lenders setting out the basic framework. I mean, I think from a starting point is look at the situation. If there's evidence that the person entitled to enforce the covenant has acquiesced in the breach, in other words, they're in full knowledge of the fact that it is being breached and are doing nothing about it, then it's quite likely you can argue that they have acquiesced in the breach, and that after 20 years, it would be considered incapable of enforcement. I mean, the law basically starts off with the historic case of Hepworth and Pickles from 1900. Which was, if I recall, was where a building had been used as a tavern for 24, 25 years in breach of a covenant. And it was held that that was not now capable of being enforced because it had been used openly for an extensive period with no enforcement being taken. But it's again, it's a question of if it's being openly used and it's clear it's being breached in that way. And if a breach is being carried out in a different way and it's not immediately apparent or obvious to the person with the benefit of the right, then benefit of the covenant, sorry, then it may not be quite so clear cut. I mean, it's a question of degrees as well, isn't it? I mean, if the covenant is you can't keep a pet, and you've got a goldfish in a bowl on your kitchen counter, then is that a breach of the restrictive covenant? Well, yes, I suppose it is, but
like an old goldfish after 20 years.
Well, it would be, yeah. So we have a series of goldfish, wouldn't it? But again, it's a question of acquiescence. And I've come across this personally in practice where an individual built 4 houses on a piece of land and kept the one at the end of the cul-de-sac for himself, imposed on the 3 houses covenants that they shouldn't build extensions without permission from him. And one of the houses built an extension without getting consent. The person with the benefit of the covenant drove past this house twice a day, once on his way to work and once on his way home again, and saw it being built, and was conscious. It looked out in his window and saw it, and then when he was approached for retrospective consent, wanted to charge many tens of thousands of pounds as some sort of penalty for damage to his reversion. Well, it didn't get away with it because it'd been done for any number of years. But again, it's a question of acquiescence is the critical thing here. So, yeah, do you want to add anything to that, Richard?
Yeah, I mean the Hepworth and Pickles, the 20 years. I mean, it was like you said, it was 24 years running this tavern without anybody doing about it, covenant not to sell alcohol. There'd been other cases which had sort of said various time periods, 15 years, 25 years, and so on. It's just that Emmet Untitled seems to have just decided for whatever reason to round everything up to 20 years. And then the lender's handbook says, if you're happy after 20 years, you don't have to do anything. Otherwise, take out an assurance. And there is an argument that after 12 years under the Limitation Act, if it's like, and the covenants can't be enforced if there's been open breaches, but they have to be open breaches.
Yeah.
Something like consent to external alterations, plans, and so on. That's an open breach.
Yeah.
But internal, not necessarily,
Okay, no problem. Getting a bit tight for time, so I'm going to look at this. Question for Richard. What is the future of community infrastructure levy as the previous government was going to abolish it?
The new government isn't, if we are running short on time. Still, there were plans that it's in the Levelling Up and Regeneration Act of 2023. There were plans to get rid of it outside, because the Mayor of London has a separate levy than on top of the boroughs, and also not Wales. Not most of the local authorities in Wales, only 3 of them, I think, have introduced the levy anyway. But they were going to get rid of, under the Levelling Up and Regeneration Act, community infrastructure levy, to be replaced by something called infrastructure levy, which would be more based like overage on your profits than on the internal floor area of the land you're building on. And it was highly complicated and going to be down to loads of regulations. It was meant to be piloted this year. But then the government, Michael Gove, if you remember him, announced that they wouldn't introduce it for the rest of the country outside the pilot for about 10 years. Labour obviously got elected in July the 4th, I think it was, last year. And in August, they basically announced, I didn't mention it in the webinar because for this reason, but they announced that they're not going to go ahead with the changes. They are going to change community infrastructure levy, but the basic principle will be the same. It's the latest.
Okay, we'll wait to see what comes of that. As I said, there's so much going on in the background, but now Michael Gove's in the House of Lords, he'll no doubt try and...
and the editor of The Spectator.
Oh, of course, yes. Let's have to bite my lip at that point. There we go. He was my local MP for a while.
Right.
There we go. Right. So one more question. Let's have a look. Where are we? I'm just looking for questions which don't cover the sort of things which we've already covered. There's one here. Is it always necessary for a buyer to enter into a deed of covenant relating to covenants imposed on a property? Okay, well, let's look at it. If it's a restrictive covenant, no, because that will flow with the land. If it's a positive covenant, then yes, if the burden of that covenant is intended to be passed on to the incoming purchaser. And the basic position is that a positive covenant will only bind the parties to that covenant, and any incoming purchaser will not be bound by the burden of the covenant unless they have agreed to take it on board. But that's strictly speaking with as positive covenants. Restrictive covenants, no, not absolutely necessary. There's a slight blurring of the lines, isn't there? If the covenant is to pay towards the maintenance, is that positive or is it restrictive? It depends if it's worded, don't fail to pay the maintenance charge, then you could probably argue it's a restricted covenant, but look at the underlying principle behind it rather than the wording. It's substance rather than form that we need to be taken into account. But I think the basic position is, for a restrictive covenant, almost inevitably no. For a positive covenant, yes, if it's intended that the incoming purchaser would become the liable to the burden of that particular covenant.
Yeah, I like the kind of "you shall not build."
Yes.
But that is a part. I always work on the basis of it, like if it makes you spend money, it's a positive covenant, no matter how it's framed.
Yeah, and again, the sort of grey area there is if you've got.
There's been cases that have said that to some extent every restrictive covenant has a positive element in it.
Yeah, of course. And I think the thing that if the covenant is not to allow a hedge to grow over a certain height, that is restrictive, but it also requires a positive act in that you've got to chop it down to stop it getting from that. So again, that's probably a segment for a whole new day for that one. But,
but Austerbury and Oldham Corporation Court of Appeal case from 1885, the most disastrous case in the whole of property law, which said positive covenants, not property rights. Don't mind third, but we wouldn't be talking about estate rent charges and the likes if they just reversed that.
Well, there we go. Okay. Well, that's all we've got time for today. Thank you for the questions. And thank you for attending the Law 2025 online Shape the Debate with me, David Keithley, and Richard Snape. If you would like to submit a question for the next Shape the Debate, then don't forget to sign up to receive emails from the Solicitors Group to be advised of future sessions. I am aware that there are sessions booked for the autumn. And as Adam mentioned previously, there is still time to book and watch the pre-recorded content from this law online with the sessions that Richard and I recorded. The online package is accessible for 90 days from the day of purchase, which obviously gives you time to look at it at a convenient time for you. And these can all be booked by going to the Solicitors Group website, thesolicitorsgroup.co.uk. And finally, don't forget to fill out your feedback form, unless you're being rude about Richard or me, in which case please feel free not to complete your feedback form. But please don't forget to fill out your feedback form once you've completed the webinars, and for that you'll receive your CPD certificate. So thank you, Richard, for taking part, and thank you, everybody. And let's all get on with our days and hopefully all have a great day. So thank you very much, everybody. See you all again very soon, hopefully.
Okay, thanks.
Okay, bye-bye.